If there is any question about the need for clarification of what Veronica said, this now would be a time to ask. If not, we can hopefully schedule a few minutes at the end, or I can imagine also you can talk to Veronique during the coffee break. Yeah? Okay, so I will invite the next speaker, which is Evy Hilderson. Evy came from Belgium, and she represents the Belgian Ministry of Labour, and she will be talking about how the well-being of workers in Belgium is taken care of from the legislative point of view. Evy, the floor is yours.
Good morning, and thank you very much for the invitation. I work for the Federal Public Service Employment, Labour and Social Dialogue as a legal advisor, and I am specialized in the psychosocial risks at work. And so I will tell you a bit more about the Belgian legislation in this field. First, I will start with the legal framework. And I would like to tell you something about the evolution we have had in Belgium, and it is an evolution that took over more than 20 years. Because the first legal action we took was in 1992 with a royal decree to protect the workers against sexual harassment at work. Then short after, in 1996, the Act of 1996 about the well-being of workers was issued. And in that act, it was the first time that we talked about the protection of workers against stress at work. There is also a collective labor agreement issued in 1999. It is the collective labor agreement number 72. It also talks about stress at work, but the difference with the Act of 1996 is that the problem of stress is dealt with from a collective approach, while in the Act of 1996 there is also a very strong individual aspect. Then in 2002 we made a new royal decree to protect the workers against harassment, sexual harassment and violence. This legislation was evaluated in 2002, and then we saw that we had too much focus on inappropriate behavior, so being harassment, violence and sexual harassment, and that inappropriate behavior cannot be separated from psychosocial load as a whole. So we made a new royal decree in 2007 that focuses on the prevention of the psychosocial load as a whole, but there was still a strong focus on inappropriate behavior. Then in 2011, again, we evaluated the legislation, and then we saw that the procedures that exist for workers who suffer from inappropriate behavior are also used to denounce other problems, such as stress or conflicts or even organizational problems. And that was because of the lack of an appropriate procedure for these issues. So the biggest change was with the new royal decree of April 10, 2014. The biggest change was that we now have also procedures for workers who suffer from other psychosocial risks. And the main goal of this royal decree is to prevent all the psychosocial risks, including inappropriate behavior, and also to improve the supervision on the legislation. The basic act in Belgium about the well-being of workers is the Act of August 4th, 1996. And I say well-being of workers because occupational health, safety and hygiene in Belgium is catalogued under a broader concept of well-being of workers. And this well-being of workers, according to Article 4 of this Act, consists of 7 aspects. And those are the work safety, the protection of the workers' health, the psychosocial risks, the work hygiene, the ergonomics, the embellishing of the workplaces, and the environment in which the work is executed. The psychosocial risks are treated in Chapter 5 bis of this Act, and it contains a number of important definitions. The first definition that I would like to explain to you is the definition of psychosocial risks at work. This is a very new definition because we have only introduced it in 2014. And it is described as the probability that one or several workers will suffer psychological damage, and this damage can also be combined with physical damage, due to the exposition to elements of the work organization, the work content, the working conditions, the conditions of employment, and the interpersonal relationships at work. The work organization is about the structure of the organization, also the way tasks are divided amongst the workers, also, for example, the type of management. The work context of content, is the task as such. This is the complexity of the tasks, the variation in the tasks, also the emotional, psychological, and physical load of the task. For example, when a nurse works in intensive care, she will have a bigger emotional load than another worker. The working conditions are about the type of employment contract or the work schedule. Also the possibilities to receive training or, for example, the evaluation procedures. The conditions of employment are about the environment in which the work is executed, and it's, for example, about things like noise or lighting or the use of harmful substances. And then the interpersonal relationships at work are on the one hand the internal relationships, so between colleagues, but also with the boss, for example, and also the external relationships with third parties. And it is also about the possibilities of communication and cooperation in the company. It is very important that the employer has to have an impact on these elements, and that means that the problems in the private life of the worker, such as a death or a divorce, are not considered as psychosocial risks at work. Because the employer, he cannot change those situations, he doesn't have an impact on them, although they can cause, of course, stress and, for example, concentration problems on the work, but they are not considered as a psychosocial risk at work. And the situations also have to pose objectively a threat, and this means that the subjective perception by the individual worker is not decisive, because one situation can be perceived as very stressful for one worker, but it can also be perceived as normal to another worker. So we say that a situation poses objectively a threat when an average worker placed in the same situation suffers a damage. We also have a definition of harassment at work. This is a wrongful complex of several similar or different behaviors. Those are manifested in words, threats, actions, gestures, etc. A wrongful complex means that we will not look at the behaviors separately taken, because an individual behavior is not necessarily wrongful. For example, when a worker, one day, he doesn't get an important email, the day after, he is not invited to an important meeting, and on the third day, the boss doesn't want to approve his vacation. Individually taken, those behaviors are not necessarily wrongful, but if you put them all together, they form a wrongful complex. The purpose or consequence of the behavior is to affect the personality, the dignity, or the physical or psychological integrity of a person, or to place the job at risk, or to create a threatening, hostile, insulting, demeaning, or hurtful environment. And this kind of behavior can become discriminatory when it is based on religion, gender, ethnic origin, and so on. Sexual harassment at work in Belgium is described as every form of undesirable verbal, non-verbal, or physical behavior with a sexual connotation, and the purpose or consequence of the behavior is to compromise the dignity of the person, or also to create a threatening, hostile, insulting, or injurious environment. And then violence at work. This is described as every act whereby a worker is psychologically or physically threatened or attacked while performing his or her work. The next few slides are about the actors who play, the actors in the company who play an important role in the prevention of psychosocial risks at work. And first of all, we have the employer. He is very important, of course, because he is responsible for the well-being of his workers, and so for the prevention of the psychosocial risks at work. And this means that he has to set up a prevention policy, and that he has to analyze the psychosocial risks and take measures to protect his workers. Then the members of the chain of command, they will help the employer by executing his prevention policy. And for example, they have to help detect problems of a psychosocial nature and make sure that those problems are solved within a reasonable time. That doesn't mean that they have to solve those problems themselves, but they can, for example, ask the employer to investigate the situation and to take adequate measures to solve the problem. And the workers, for their part, they of course have to protect their own safety and health, and also the health and safety of their colleagues. And they have to abstain from inappropriate behavior or misuse of the procedures. Then the legislation also requires every employer with more than 50 workers to set up a committee for prevention and protection at work. And this committee consists of the employer, his representatives, representatives of the workers, and prevention professionals. And the main function of this committee is to give an advice about measures affecting the well-being of the workers. Then, especially for psychosocial risks at work, we have two very important actors. On the one hand, the prevention advisor, who is specialized in the psychosocial aspects of work, and on the other hand, the confidential counselor. In every company, there has to be an internal service for prevention and protection at work. And this service, internal service, consists of prevention advisors. They are experts in the well-being of workers. And the legislation says that when not all problems, according to the well-being of workers, can be solved by this internal service, then the employer has to make an appeal to an external service. And the prevention advisor specialized in psychosocial aspects of work will either be part of the internal service or the external service. He is a prevention advisor with a specific education. He has to have a master's degree in psychology. And he plays an important role in the procedures that exist for workers who suffer from psychosocial risks at work. Depending on the procedure, he will either give an informal or a formal advice, but I will talk about that later on. His function is protected, and that means that for his dismissal, the employer has to follow a certain procedure, and he is also bound by professional secrecy. Then we have the confidential counselor. His appointment in the company is not obligatory, but it is highly recommended. And in general, it is a worker in the company who will execute this function in addition to the other work that he does in the company. He has to receive certain training in order to obtain the necessary competences and knowledge to execute his function. And he will play a role in the informal procedure, so he will give an informal advice to the workers who suffer from psychosocial risks at work. And he also is bound by professional secrecy. Now, the prevention of psychosocial risks in Belgium is based on the risk analysis. And this risk analysis, the analysis of the psychosocial risks, can happen either before any problem occurs or when a danger is identified in a particular situation. The risk analysis before any problem occurs will be carried out on different levels. First of all, of course, on the level of the whole organization, then on the level of the different divisions, and then also on the level of the individual worker. And based on this risk analysis, the employer has to take preventive measures. First of all, of course, to prevent the risks. If certain risks cannot be prevented, he will have to take measures to prevent damages. And at last, when damages cannot be prevented, he at least has to take measures to limit the damages. The risk analysis can also be carried out when a danger is identified in a particular situation. Of course, the employer himself can take the initiative when he detects a danger in a specific situation. But the legislation also gives the possibility to a member of the chain of command or to 1/3 of the representatives of the workers in the committee to ask the employer to analyze the situation and to take measures to solve the problem. When in the company there is a risk of violence caused by third persons, the employer has to set up a kind of registration system, and the acts of violence will be registered in that system, and then based on this registration, the employer will also take adequate measures to protect his workers. The legislation also says that the employer has to evaluate the preventive measures. He has to do this every year, and of course adapt the measures when necessary. In every company, there has to be an internal procedure, and this is for workers who suffer from psychosocial risks or from inappropriate behavior. And there are two types of internal procedure. On the one hand, we have the informal psychosocial intervention, and on the other hand, we have the formal psychosocial intervention. The informal psychosocial intervention will be carried out by the confidential counselor or the prevention advisor. And the goal is to find a solution by the means of discussions or a reconciliation between the two parties, or to give a simple advice to the worker. And in fact, 80% of the cases are solved by this kind of informal psychosocial intervention. The worker can also choose for a formal psychosocial intervention, and this can only be carried out by the prevention advisor. And it consists of a risk analysis and the proposition of measures to solve the problem. Here there are also two types, depending on the nature of the cause of the problem. When the cause is rather of a collective nature, this means it is rather an organizational problem and it affects more than one worker, then the procedure has to be carried out by the employer himself with his committee. This means that he will analyze the situation and ask an advice of his committee about the way the problem has to be solved, and eventually they will take measures to solve the problem. When the cause is rather of an individual nature, such as a conflict between two workers, then the investigation will be carried out by the prevention advisor. He will investigate the situation and write a report for the employer in which he will propose measures to solve the situation. But in the end, the final decision on the measures will always be taken by the employer. When a worker is a victim of violence and harassment and he starts up a formal intervention, he has the benefit of an additional protection. And first of all, this means that the prevention advisor, in case of a serious damage, can propose measures to protect the worker immediately. And a serious damage is, for example, a risk that the worker will have a depression very soon or a burnout. And then he doesn't have to first analyze the situation and write a report. No, he can immediately propose measures to the employer to protect this specific worker, and then, of course, the employer has to apply those measures as soon as possible. The worker is also protected against retaliation, and this is also the case for the witnesses, so the people who have seen the inappropriate behavior. And it means that the worker cannot be dismissed, nor can his working conditions be changed, except for reasons that are alien to the intervention. If he is dismissed or his working conditions are changed, he can start a procedure before the court, and then the employer will have to prove that the reason for the dismissal or the change in working conditions is alien to the intervention, and this is during a period of 12 months after the beginning of the intervention, of the internal procedure. The worker can also get a compensation when he has been dismissed or his working conditions have been changed. And here he can choose between the compensation of his real damage, but then he has to prove the size of his real damage. Or he can also choose for a lump sum, and that is 6 months of wages. So that, what I explained were the internal procedures, but there are also external procedures, and those consist of the filing of a complaint with the inspection, or the introducing or the start of procedures before the court. This inspection is a part of our Ministry of Work, and when a worker files a complaint with the inspection, they will check whether the legislation is respected by the employer. And if they see that he does not respect the legislation, they can impose measures, for example, the setup of internal procedures, because sometimes we see in companies that they don't have internal procedures yet. It is also possible that a worker starts a formal intervention and that the problem in the end is not solved because the employer does not want to take the adequate measures. And then he can also file a complaint with the inspection. And then the inspection can impose the measures that were recommended by the prevention advisor, or they can also impose, of course, other measures who protect the worker. The actions before the courts consist of criminal actions or civil actions. The criminal actions are a complaint with the inspection, with the police or with the public prosecutor, and they will be carried out before the criminal court. And when the judge thinks someone is guilty of committing harassment or violence, he can be sentenced to detention from 6 months to 3 years, or he can be sentenced to a fine from 3,600 euros to 36,000 euros, but those sanctions can of course be combined also. The civil actions are taken before the labor court. And the worker can ask the judge to do different things, such as the injunction to cease the behavior. That means that the judge will oblige the perpetrator to cease his inappropriate behavior. And if he doesn't cease his behavior, he will have to pay a fine. The judge can also impose measures on the employer, for example, the appointment of a prevention advisor, and the worker can also get a compensation. Here again, he can choose between his real damages or a lump sum of 3 months of gross wages. But the lump sum will be 6 months of gross wages when there is discrimination, when there is a relation of authority, so when the employer has harassed the worker, or when there is very severe behavior. The Belgian Ministry of Work is still taking several actions. In the past we have done scientific research, but now we also still make intervention tools, and what we have done is we have made a model for diagnosis to diagnose whether in a company, for example, there is a risk of stress or burnout. And we have also made a method for a risk analysis, and one that is often used is the Soban strategy. And that one is also available in English, and you can find it on our website. We also organize information sessions. We have made brochures and posters and so on. And for me, as a legal advisor, what is very interesting are the professional networks with the prevention advisors and the confidential counselors, because they give us feedback about the application of the legislation. So that is when how we can see that maybe something isn't working in the field or is too complicated. And all these actions result in a continuous evaluation of the legislation. If you would like some more information about our research or tools, you can find it on the website of our ministry. There you can find the legislation, and the second website, www.beswic.be. That is a special website about the well-being of workers. Thank you very much for your attention.